Hello everyone, you're all very welcome to this special pre-Christmas webinar on open source evidence and the investigation of international crimes. I can see the attendees list is creeping up by the minute, so we'll just wait a second just until everyone joins us. Now, I can actually see in our attendees list a huge number of friends and colleagues from around the world, including many lawyers practicing before international tribunals, colleagues from international organizations, academics, human rights activists, and advocates. Judge, hello. So yes, great, wonderful to see you all. Thank you all so much for joining us, and we hope you'll find this an interesting and thought-provoking discussion. Just briefly, by way of context to this event, as many of you will know, open source information plays an increasingly important role in the investigation of international crimes and in human rights investigations today. And I think that's particularly true for digital open source information. So that's defined by the Berkeley Protocol as information that's on the internet that any member of the public can access, be it through observation, request, or purchase. And I think that kind of information is only going to play an increasingly important role as we go on. And it brings many potential advantages, including overcoming access barriers, hearing from a more diverse range of voices, perhaps. But as my colleagues and I from the OSR for Rights Project have been keen to point out, this kind of open source evidence is just as vulnerable to gaps and biases and vulnerabilities as any other type of evidence. So it's important to not view it in a vacuum and to avoid treating it as a panacea. Now, without further ado, let me introduce the panel. So firstly, we have Her Honour Judge Joanna Korner, QC. She's a judge of the Crown Court of England and Wales, having previously spent 8 years as senior prosecuting trial attorney at the ICTY. Judge Korner, as many of you will know, is the UK's nominee for the 2020 elections for judges of the International Criminal Court. And I had hoped that we'd be in a position to mention today that she'd just been elected to the ICC bench, but a snowstorm in New York yesterday meant that the Association of States Parties meeting couldn't go ahead as planned. So we continue to keep our fingers crossed for Judge Korner, who no doubt would make an extraordinary contribution to the court, and we'll hope for some good news later this evening. Lindsay Freeman is Director of Law and Policy for the Tech and Human Rights Program at the Human Rights Center in the University of California, Berkeley. She's an experienced international lawyer with particular expertise in the use of technology, in digital evidence, and online investigations. And Lindsay led the drafting team of the recently launched Berkeley Protocol on digital open source investigations. This is a collaboration between the Human Rights Center at Berkeley and the UN Office of the High Commissioner for Human Rights. And Alan Teeger is a senior prosecutor at the Kosovo Specialist Prosecutor's Office. He's got a wide range of experience as a federal prosecutor in the US. He was involved in the successful prosecution of police officers in the Rodney King case. And he was among the initial group of prosecutors and investigators at the ICTY and served as a prosecutor in the ICTY's first case, Tadic. As a senior prosecuting trial attorney for the ICTY, Alan led the investigations and prosecutions of many high-profile political and military leaders. So thank you all for joining us today. It's a real pleasure. I'm really looking forward to our discussion. So how it's going to work is I'm going to ask the panel a couple of questions before turning to the audience for Q&A. So please do submit any questions that you do have at the bottom of your screen using the Q&A function. I'll start with you first, Judge Korner, if I may. What do you see as one key benefit and one key challenge of using open source information of any type in international prosecutions?
First of all, Yvonne, can I thank you very much for asking me to take part in this panel. Apart from anything else, it's given me a chance to at least see Alan for the first time in a very long time, even if not in real life. I think it's worth saying a little bit about the background to this. The trials at ICTY, which of course were the first international trials after Nuremberg and the Tokyo trials, really, to begin with, very much relied on open source material as the beginnings of investigations. When I turned up later than Alan and after the Tadic case at ICTY, asked to prosecute the cases, the case of Bergen and Talic, I arrived before I was due to start and said to the investigator, okay, can I have the evidence, expecting to find files of statements and documents and all the rest that one would expect when beginning a prosecution. And he handed me a single lever arch file, which contained, I would say, roughly 80% newspaper reports of the conflict in the former Yugoslavia. And it was very lucky that in the end I had a lot more time to investigate than I expected, because using those reports, we could then go on to find, we hoped, witnesses and documents, although a lot of documents were received through seizures of material in particular in the Republika Srpska. So one has got to look at the beginnings there to realize just how important it has been from the early days of international proceedings. It's equally become more and more important even in domestic cases, because of videos being taken and the desire of many criminals to go onto YouTube and also obviously Facebook. But as far as I can see, there are two, well, there's one major benefit and one major challenge. The major benefit, of course, is you can acquire evidence in its broadest sense of crimes being committed which you might not otherwise have. And the classic example is of course the filming of the bombing raid in Yemen, where it appeared, I think, on YouTube and was, I think, pretty much the only record of this particular bombing. And that's the obvious benefit. The obvious challenge is, how are you going to persuade a court to admit it as evidence, and how are you going to persuade them that it has reliability as evidence, particularly if it has been uploaded anonymously. It is unclear who has uploaded it, and in these days of manipulation of digital images, it's always going to be an enormous challenge to try and prove that it is reliable evidence. So in short form, that's my answer to the question.
Lindsay, that's something that I know you've been mindful of in working on the protocol.
Yes, thank you. And my sort of key benefit and key challenge are not all that different. I think one of the key benefits of digital open source information is its accessibility. You know, while conflict is happening, you can get information coming out of the conflict. So it bridges the temporal and geographic gap that is so often a problem in international criminal and human rights cases. It connects victims with, you know, prosecutors or investigators in The Hague. And that's a really great thing. Also, I think in terms of the speed at which an investigator can, you know, plan an investigation and start getting information before actually landing on the ground, it's very helpful. And I think the just overall efficiency of investigations when used for the sort of intelligence, operational, and security purposes. The major challenge, though, is the doubt, I think, that can be raised, because it's so accessible and people can put so much information out so quickly without any vetting procedure. And so you see a lot of disinformation and counter narratives coming out as quickly as you're getting the facts. And so that raises this doubt, and you have disputed facts from the very beginning of your investigation. So verification, which we stress a lot in the protocol, is extremely important. Verification done by the investigators, I would say, tied to digital literacy of the people who are trying to understand that information.
Thanks, Lindsay. And Alan, what do you see as one key challenge and one key benefit?
Thank you, Yvonne. Really great to be here with Joanna and with Lindsay and with you. Like Joanna, I was struck by memories of the early days of the ICTY, and even farther back than she recalled, because it was because of the role that open source played in the establishment of the institution that gave rise to the possibility of the prosecutions we're talking about now. And it was the establishment of a commission of experts to collate and assess open source information about the conflict that ultimately led to the establishment of the ICTY. And as Joanna also pointed out, open source thereafter played a significant role in various aspects of the ICTY investigations and prosecutions, not the least of which was a reflection of the kind of overwhelming news coverage of the conflict at the time, and the relative inescapability of some aspect of notice to the leadership figures of allegations of crimes by the forces under their control. So given that backdrop, you might think that I would consider the key benefit of digital open source to be the expansion of the availability of this kind of information for investigators and prosecutors. And while I don't discount that, for me, the most extraordinary aspect of digital open source has been the kind of expansion of the availability and the kind of sense of entitlement and opportunity to put views of individuals out in public. And maybe not even an entitlement to put your views out in public, but even a compulsion and an obligation to do so for all kinds of people. I was reminded of investigations in the US where it took somber reminders of the importance of telling the truth in a grand jury and the penalties that could follow if you told a lie about certain matters to extract concessions of racial animus, where those issues are divulged daily on in social media and put out in public platforms. So that has been an extraordinary transition that I think is useful in many ways. The challenges that occurred to me are, among other things, flip sides of the benefits. Number one, it's an enormous amount of information, and it puts an extraordinary burden on prosecutors' offices to collect, maintain, store, assess, and to the extent that I've heard suggestions of the possibility of outsourcing that task in certain ways. The other challenge that occurs to me is trying to stay as engaged in the opportunities presented by that vast material. And I have in mind the head of the New York Civil Liberties Union, who pioneered a process of using some kind of old camera equipment to freeze frames in either documentaries or movie stills, and that was a groundbreaking effort that resulted in some groundbreaking litigation and a successful exposure of police brutality. And those new opportunities occur all the time, and that's the challenge presented by the vast array of information that digital open source presents.
That's interesting, actually, because I think you know, the Joanna and Lindsay's key benefit is sort of almost the crime base or contextual information, but those examples you've given are about how actually, in the right circumstances, open source evidence might be used as even direct evidence in trials. And I think we're seeing that both domestically and internationally. But I wanted to pick up on this point that all of you have touched on the vast scope of material and open source information that can be generated. I suppose I was thinking about how in recent practice, the ICC has moved away from this doing admissibility considerations on each individual piece of evidence, and instead deciding to consider issues of relevance, probative value, potential prejudicial effect in relation to all submitted evidence at the deliberation stage of proceedings. So submissibility, as people are calling it. So I'm just wondering, do you think this submissibility approach can be squared with the use of digital open source evidence in particular, where you've got potentially millions, if not hundreds of thousands of relevant videos, images, social media posts? Lindsay, what do you think about this?
Well, to be honest, I think there are some problems with the submissibility approach to begin with. You know, I see three different pieces to that. One is just the deferred determination, where the parties don't find out what's been admitted to the record and what's being relied on until the judgment comes out. It's also this holistic assessment, so you don't know how each piece of evidence has been weighed. And then at least at the ICC, the inconsistency between chambers, because the rules of procedure and evidence allow each chamber to choose its own approach. And those three things create an enormous amount of uncertainty, which is problematic for all parties, and I think has resulted in this approach of throw everything at the wall and see what sticks, which is not very efficient. It kind of clutters the evidentiary record. So these issues that already exist, I think, will be exacerbated with digital evidence if the submissibility approach continues. And I've actually co-written an article with Raquel Vasquez Llorente about this that will hopefully be coming out soon. But with digital evidence, it's incredibly complex. So I think there is benefit in having those evidentiary hearings and having the parties hash out why they think it is something that is authentic and reliable at the time it's being admitted. I think just cognitively, if you first see the evidence and see how it's valuable to the case and then assess whether or not it's something you can rely on, that's sort of a backwards approach. I think the safeguarding is this something we can rely on, and then seeing its value to proving your case. Also, because digital forensics has become more of an art than a science. I think it's not, I think originally when people were talking about digital forensics, it was compared to scientific evidence and this expert evidence. But it's really quite different now with the amount of information we have available. And finally, digital open source information, even though it's open source, implicates a lot of privacy rights. And these are rights of individuals. It might be the rights of the accused, but also rights of third parties, which are incredibly important to protect and establish. So admitting evidence into the record without going through those safeguards and ruling or looking at the privacy implications, I think will be more and more problematic as well.
Thanks, Lindsay. That's actually a really interesting point. We might come back to that one on privacy in a bit. And actually, I can see Raquel, your co-author, is with us. So hello, Raquel. Thanks for joining us. We might hear from you in the Q&A. Alan, any thoughts on this submissibility approach?
Well, I don't want to enter into the debate on the merits or demerits of submissibility in general, but try to comment on its interface with digital open source materials and the quantities that might be relevant to a particular case, and the manner in which I understand the practice of submissibility proceeds. Now, I have to preface that by saying my understanding is that it doesn't obviate the standards of reliability and probative value and provenance and all the rest. And those factors need to be addressed by the proffering party at the time. It's just you don't get the benefit of a decision. So that's the context in which I'm offering these comments. And also with a little, perhaps, maybe taking on a tiny bit of responsibility collectively for bringing the state of jurisprudence to this pass. And I'll also blame my esteemed colleague because she will have done this too. Some of the backdrop to this, I think, is the approach that was taken by prosecutors in the ad hoc tribunals. In view of the vast amounts of evidence they needed to grapple with that had informed their judgment of liability and relationships and policy, and wanted to ensure the judges would hear that. And so when it came time for admission, you would often hear the argument that, Judge, it'll be up to you ultimately to determine the weight, and you'll be best in the best position to do so, the totality of the evidence. And so you should, admit it, and you'll be in a perfect position to decide how much weight you want to give it. Now, that argument made admissibility more likely and easier, but it also tended to downgrade its significance in some way, and presumably shorten the distance between where admission practice began and the submissibility standard today. And I also understand, the obvious differences in approach. Some people kind of like it because it avoids procedural wranglings in court. Other people can't stand it because they don't know where they stand. And are concerned that they've built their case on sand rather than on some solid foundation. I think generally my experience has been, and I'll be interested in whether or not Joanna shares that there's kind of a self-balancing protective aspect to even not to the process of having evidence in, not knowing either whether the judges will admit it or how much weight they'll give it. The likelihood that you're going to be pinning your hopes on evidence that the judge wouldn't even admit, in most cases, is pretty low because you understand the judge's concerns generally. And even if you're not certain about how much weight the judge will allot it, admissibility isn't really the question. And that's why I think digital open source evidence is vulnerable for two reasons. Number one, you really don't have the same in-depth, over time sense of where judges stand, and the likelihood of certain judges harboring skepticism or doubt about the reliability of digital open source information is higher, I think, than it would be in other circumstances. And secondly, as Lindsay pointed out, you'll often be relying on a lot of it. And so you've got this risky combination of a great deal of the prosecution evidence being of a particular category, and not having the benefit of at least some solid sense of where the judge stands on it, what he's concerned about, and what you might be able to address in the meantime. I also suspect the efficiencies provided by not arguing about it in the first place may be undercut by the risk that prosecutors in particular, not knowing whether they've convinced the judge about the authenticity of and reliability of those documents, will call many more witnesses than necessary for that purpose.
Yeah,
So.
it's such a good point. And I think, you know, I can see colleagues in attendance who are involved in advising NGOs and advocates about this is how you collect it, including Lindsay through the protocol. This is how you collect open source evidence. This is how you should preserve it. But if you don't have these admissibility decisions to give you that benefit of what the court might require, then you're kind of acting in a vacuum almost. Joanna, what are your thoughts on this?
I just want to go back to something Lindsay said, which is the inconsistency of approach, which was not only adopted in the ad hoc tribunals, but has appeared regrettably in the ICC. And I had to read through the 350 pages of the experts' report, the recommendations for the various questions I was going to be asked. And I note that they didn't make a recommendation about admissibility as opposed to submission. It does seem to me, and I think it's going to be highlighted by, as you point out, the large amount of open source evidence that is available, that there is an argument for saying it should be the admissibility test which is applied, rather than throwing, as I think also said, the kitchen sink at the judges. For really one main reason, which is that if you know that a document has been admitted, and you are able yourself as an experienced prosecutor to assess the likely weight that the judges are going to give it, unless they go off on a complete frolic of their own, which I suppose is possible, you stop having to call further evidence on the topic. And one of the major criticisms, of course, of not only the trial at the ICC, but ICTY and even more so ICTR, were the length of trials. And part of that is due because you didn't know whether the evidence was accepted or not, or the documents had been admitted. The other aspect, which is slightly divergent, is which the Americans and I always had a discussion about, is the requirement to put your case. And one of the reasons why we say it's important to put your case to a witness is because if you know what the case is, then you have the issues defined, you know what evidence you need to call. If there's no requirement, and it's exactly the same with the admissibility. So I very much hope that there will be a consensus reached on how evidence does get into to play before the judges, because the other reason is at least all sides know then, both defense and prosecutor, what they need to do. So I am very much in favor of the admissibility test.
Thank you very much. One final question from me for all the panelists, and then we will turn to audience Q&A. So please do feel free to put any questions you might have for the panel in writing in the Q&A box. So my final question is this. Some scholars have warned that a move towards incorporating more digital open source information in accountability processes might lead to some crimes, like, for example, crimes of sexual and gender-based violence, becoming invisible, because these tend to be captured less in the format of digital open source information. On the other hand, some authors like Alexa Koenig, our friend, and Lindsay's colleague from UC Berkeley, writing with Ulla Geoghegan, who's a PhD student here in Swansea, have argued that evidence of these types of crimes does actually exist. It's just that investigators sometimes don't know how to look for it. So what are your thoughts on this? Do we risk failing to learn the lessons of early international criminal investigations as we move into doing investigations in this new digital environment? Alan, I'll turn to you first.
Well, I'm not sure I'm going to be in a position to resolve the debate between Alexa and Ulik and others. And I'm not entirely sure what lessons of the early tribunals you may have in mind. And in fact, given their sui generis nature, almost everything we did served as a lesson. Either we got it right, and that's a lesson about how to do it, or we got it wrong, maybe more often, and that was a lesson in how to improve it. But let me look quickly at the two scenarios you presented and see how they implicate those some of what may have been practiced at the ICTY and learn from it. So first, Alexa and Ulik's view that if you deploy digital open source investigative efforts in a particular way and with a proper focus, it won't render crimes of sexual violence invisible, but quite the contrary. Now, of course, the ad hoc tribunals and the ICTY in particular, in its early days, were operating with very different tools and focused on different sources of evidence. But of course, you had the same issue of, are you deploying that mechanism to its most effective use? So let's take a simple one like, I mean, we were reliant on witness statements and to a large extent in the early days. And we sent out trained investigators from domestic systems to do those interviews. So it was not hard to figure out over time that sort of an inadequate understanding of the history or cultural insensitivities or a failure to grasp the nuances of certain aspects of language were blunting efforts to get all of the information, and sometimes in a kind of systemic way, that it would have the same effect on multiple witnesses, neutralizing the effective receipt of evidence. So I think that to the extent that the view that you can do this in a different way and do it better, that's a classic lesson. But the lesson is really to look at it, not to be complacent about it. And that's, you know, it's easy to say once you see it happening, but it's not always implemented rigorously and systematically. The second scenario, the risk that by relying on the results of open source, what it reveals, you risk overlooking significant crimes. It is a reminder that no particular investigative tool is a magic bullet. Sometimes it'll get you a lot, if not most of the evidence you need. Sometimes it'll serve to provide a significant proportion of what you need, and sometimes it'll get you very little of what you're looking for. It's simply no kind of panacea, and you have to keep that in mind. And that's, I think, particularly dangerous when that tool is kind of the newest, brightest, shiniest in your toolbox. There's always a risk of over-reliance. So you can't, you have to define your investigative objectives and the tools that are necessary to get there, but not let the tail wag the dog of the investigative policies you're trying to pursue.
Thanks, Alan. Joanna. Oh, you're on mute. Hang on.
Yeah, it's quite interesting, actually, that aspect of things, because the first part is the investigators overlooking evidence. There's no doubt at all, and indeed I think it's happening in at least most sophisticated investigative agencies, that investigators are being trained to look for the sort of material that does appear on YouTube, that does appear on Facebook, on Instagram, obviously the ones where it's wiped out immediately, TikTok and all the rest of it. It is more difficult, but the training should obviously also incorporate that should, to begin with, only be the starting point for a proper investigation, because it is always going to cause problems if all you're left with is what is on Facebook or YouTube without any indication or any real indication as to its provenance or its reliability as a piece of evidence. And so I think that's really important, that nobody thinks, okay, we don't do anything else, we just go on YouTube, download it and throw it in. It's part of the case. That should only be the start, and if you like, the end point when you really can't do anything to find any further evidence. The idea that sexual crimes, for example, would be overlooked because by and large they occur in private. People do not tend to commit rape in full sunlight. Even in the Rwanda conflict, they drag them into the bushes and the like. But of course, it becomes known, and in the Rohingya investigation that's going on, in fact, a number of investigations that are going on, in a way, regrettably, the refugees who were allegedly being raped were filmed by various, unfortunately, uninformed investigators in circumstances which I hope will never be repeated, in the sense that the women who were interviewed didn't realize that the videos were going to be put up on YouTube. They weren't told that. But so therefore, if they tell somebody and they tell somebody else, it eventually does emerge. It just takes a little bit longer. So I don't think that's, as Alexa says, Alexa Koenig, that it's a real risk. But I do think that open source material, as I say, should be a stepping stone and only be put in evidence if you really can't get fully accredited evidence, if that's the right way of putting it.
Thank you. And Lindsay.
Thank you. I have a couple comments on this, and I kind of want to address the question as a whole, but also the idea of sexual violence in particular. But just to start by saying, I don't think anyone, or at least hopefully no one, is seeing digital open source evidence as something that replaces other types of evidence or other types of investigations. I see it as another tool in the tool belt with all the other tools you have for investigations. So my concern about it sort of replacing these other things, I don't think that's problematic as long as you continue with investigations as they've been done and just add this in. But in terms of the idea Well, I think it's kind of interesting that people use sexual and gender-based violence to talk about crimes that might not be shown on the internet, because actually it seems to be one of the crimes that is shown quite a bit, from the Steubenville rape case in the US to the La Manada case in Spain. You have these rapes themselves recorded and spread around to show off or for whatever reason. Nicholas Kristof actually did an expose, I think last week, on Pornhub and the hundreds of thousands of videos of rape on Pornhub. And so if you're on the internet a fair amount and you're doing open source investigations, you're actually going to find that one of the ways people are using the internet is to abuse women in every shape and form that it comes in. So I think the assumption that it wouldn't be shown just isn't necessarily true. So I think the fact that it hasn't been used as much as evidence or isn't being presented, and I think this might be one of the things Ulick and Alexa have been looking at, has to do more with the bias of the investigators and the makeup of the investigators, not of the evidence itself. And open source investigations has been very male dominated for a long time. Hopefully with all the students we're training at Berkeley, that dynamic is changing. But I do think it has to do more with investigator bias than actual evidence that is available. And on that point, I would say it's very important to think about where the bias comes in when you're doing open source investigations. And when we train on it, we kind of highlight 3 specific spots. One is bias in what is uploaded to the internet, and people have different access to technology in terms of different genders, different minorities, different rural versus urban areas. Certain voices are going to be amplified and certain voices are going to be missing. So just in terms of what information is uploaded to the internet, there is inherent bias there. Then you have the architecture of the internet and all the built-in algorithms that have their own bias. One person's doing a search here where I am in California and another doing the same search in The Hague make very different results because of the location they're searching from. So everyone gets shown different information and there's that bias built in. So you have to take actually active measures to counteract that and get objective search results. And then finally, it's the cognitive bias, or whatever you want to call it, of the investigator themselves, of how they think and perceive the information they're seeing. So I think there are measures you can do to counteract it, but being very conscious of these different dynamics is going to be quite important into counteracting this potential problem.
Super interesting. Thanks, Lindsay. Shameless plug here. Myself and Alexa and Darren Murray from our project have actually just written a piece on bias in digital open source investigations, which touches on some of those points. So watch this space. Okay, so without further ado, I'm going to turn to the audience Q&A. I'm going to do my best to try and get through them. So please do keep your questions coming in. I can see our first 2 questions are kind of on a related theme, and the theme is about takedowns of content. So these are questions by Ricky Parry and by Sam Dubberly, our friend and colleague from Amnesty International. So I'm going to read out Sam's question because I think it encapsulates Ricky's as well. So Sam asks that a lot of content disappears from social media platforms showing possible crimes. This might be because governments have requested to take it down, or it could be that the social media companies themselves have algorithms that say this is extremist content, and so it just disappears. And Sam says that requests to the companies for them to provide the content for accountability reasons are often rebuffed. So his question is, how can we ensure that content that is no longer online can still be used in courts and tribunals? He says, in a world where social media companies have so much power. Anyone want to come in there on that? So I guess there are probably 2 parts to the question. One is, firstly, can we still use content that was once online and has been taken down or no longer exists on YouTube, for example, or Facebook if it's gone? And I suppose the second is, what tools do lawyers practicing before international tribunals have to subpoena the social media companies or to ask them for this information? Lindsay, do you want to come in on this?
Sure, I'm happy to. I mean, this is a problem that has been going on for a long time, the disappearing of content with evidentiary value, and one many different groups are working on, and there are different efforts with the tech companies. And this is an area Alexa in particular has been working on for many years on different types of digital evidence locker approaches that might be helpful in terms of solving this as a problem. Because if the content is taken down due to terms of service and not retained because no one's asked for it to be retained, it does get written over and it can disappear. I mean, that is the nature of digital content, is it can disappear forever, and you have that as a problem. So it comes to working with the tech companies to get them to preserve the content. Where I think there is a lot of tension is there's a few different stakeholders and they don't necessarily have the same interests. I think it's a bit of an easier solve for prosecutors' offices in an international tribunal than for civil society who also want access to this. And I think you have a lot more terms, at least, to define and clarify if you're going to have civil society actors be able to make requests that would compel content from a social media provider, in particular, what safeguards are there and what privacy protections are put in place for that to happen, and how you're defining civil society and how you're going to have oversight so that it doesn't get abused. Also, some of the issues I think are faced of, if you are preserving this content, storage costs money, takes time. So it's who's going to be responsible for the cost of it, who's going to oversee it and be the sort of arbiter of who gets access and make those decisions, and where is it going to be held? You have this issue of many of the tech companies are US based, and so it gets very tied in with US laws. Like I saw the question asking about Section 230, I think, of the Communications Decency Act, which I don't know that it necessarily, I think it applies to this or makes a difference in terms of this conversation, but it makes it very easy to see American-centric framing on how this problem is solved. And I think that's going to be problematic. We need to look at, the GDPR framework in Europe as well. And I think it's going to be an international problem, which we need to address with all the different stakeholders involved and an international perspective.
Thanks, Lindsay. Judge Korner, do you like to come in here?
Well, actually, I thought, because Alan is actually dealing with this as a prosecutor at the moment, but it seems to me that it highlights the importance of the chain of custody. In other words, let us say, for example, you are an investigator, and let's take, I was going to say Kosovo, but I don't probably think that's not a very good idea. But let's go back to the Bosnian investigations, that if an investigator saw that something had been uploaded onto YouTube, which related to an incident of one of the mass killings, for example, and was clearly an amateur video taken, which we did have some, but the people who had taken them gave them to us, so we had the chain of custody in a sense, but downloads it, stores it on a digital function, then he has got to record everything that he has done, how he found it, where he stored it, when it was stored, and all the rest of it. And hope that if in itself it can be shown from other material to be of some credibility, that the efforts of the investigator to document what he did will allow it to go in, even if it has disappeared by that stage off the internet. and certainly Bill Wiley's lot, the name of which I always forget, that has been doing a lot of the collection of material from Syria, and indeed Myanmar and other places, I know has developed through people I know who work with that, a very strong protocol about this type of stuff. So I don't see in itself it would make it impossible to produce the evidence. It would be better if it was remaining, but that's about it. But Alan, as I say, I think is probably more up to date on this.
Yeah, but you know how reticent investigators are to disclose any aspects of an investigation, Judge Korner, and no one more so than me. I think the question looked to a very significant stage, which is what happens when it's off, and that implicates, for a variety of reasons, the need to be as rigorous as possible about avoiding a situation where those complexities arise. So, of course, there are tools available, including subpoenas, for pursuing material that's been removed from open source availability, but to the maximum extent possible. The more efficient course is to be, but demanding course is to be monitoring as actively as possible, and taking down material before that happens. Now, you may still want ultimately to be in contact with the ultimate provider for authentication purposes and for various aspects of metadata, and for as investigations transitioned into an increasing reliance on open source material, as nobody knows better than Lindsay, the need to train investigative staff in the methods of review and takedown with integrity and storage with integrity and maintenance with integrity was heightened. I mean, Lindsay in particular and Berkeley in general have served offered an enormously valuable contribution to investigations in doing that. So, and I think someone also mentioned the complexities of various and sometimes contradictory standards in different national jurisdictions for what's permitted and what's not, and coordinating those efforts and ensuring that no investigation runs afoul of those restrictions and those standards. So it's once in every aspect, the seemingly simple task of seeing something seems to be available to the entire world, and you simply want to preserve for ultimate use in court, is often much more complex than it appears, and certainly doesn't get easier once the material is no longer publicly accessible.
And what is Section 230 as a matter of interest?
Who mentioned Section 230? Lindsay.
One of the questions did. I've never heard of it.
It was in the questions, but I believe that's the one that says social media companies aren't the publishers themselves, aren't looked at publishers in the same way as the New York Times might be, since users are generating the content, so they don't have necessarily the same level of liability for what gets posted on their platforms. But I think and I don't know it well enough to go into the details right now, but I think there's some revisions or reforms that might be coming up on that.
So, and that becomes interesting when it comes to things like hate speech hosted on the platforms. You know, what is the role of the platform? Are they a publisher in the traditional sense, or are they the equivalent of a phone company? You know, so these are really tricky issues that I think we're still figuring. Sorry, Lindsay, do you want to?
Oh yeah, and sorry about that. Sorry. One of the other things I wanted to say, just in response to, well, Alan's comments about preservation and good documentation. I mean, these are the key. And if you are, as an analyst or investigator, able to diligently monitor the content and preserve it in a timely manner and document that preservation, I don't really see any issues with its admissibility down the road. I think and now there's also really great tools available where you don't need to have extreme technical skill. Really, just in one click, it does the forensic capture. So anyone can use it without a ton of training. And I think that is incredibly helpful for investigations. But you still have the issue of volume. And even if you are diligently monitoring the situation, I don't know any investigation at any of the tribunals that has the manpower to really do that properly and catch everything. I think the other issue is the platforms are now using artificial intelligence to identify and remove this content. So it is getting removed within seconds of being posted, so that investigators are unable to even know it's there, see it, be able to capture it in time. So I think that's why the conversations with the tech companies and other solutions are being looked at, is really that introduction of artificial intelligence into the takedown process.
I can see a great question has come in from Marissa Carden-Weber. Thanks for your question, Marissa. This touches actually on something that Lindsay sort of mentioned in passing earlier, and I'd hope that we might get back to, which is on privacy. Marissa's particular question is on the rights of victims depicted in this open source evidence. So she says, how are the rights of victims depicted implicated, and are there preferences on the use of such evidence considered? So I suppose, for example, if you have evidence of some mass atrocity, maybe a shelling, you know, and you've got pictures of victims included in that, is there any way of seeing what their preferences are and taking those into account when making the decision to include this evidence? Any thoughts on this?
Yeah, it's a very difficult question, as you say. Somebody films a bombing or a marketplace shelling or whatever, and the bodies of victims, and the families have no notice that this is going to be shown. The difficulty, of course, is how do you trace the victims or their families who are shown? I certainly strongly believe that people who are victims or complainants, let's be careful, complainants about crimes being committed against themselves should certainly have the right to be told that it is going to be shown on the internet before it is shown, and it should be an offence not to seek their permission, except in certain circumstances. It's always, isn't it? It's a question of balance. Is it better that the perpetrators may be brought to book this way, even if the victims haven't consented to its being shown? Or should the right of the victim outweigh that of the public good in bringing a perpetrator to book? It's not an easy question.
This is probably something you've had to consider in the context of the ICTY, where, for example, you're introducing images of mass graves or other content that might show individuals. How is this sort of grappled with?
Well, I was reminded of Joanna's encouragement to investigators to, insofar as possible, follow the trail of the digital evidence to the real people involved. And I think things do change then once someone who's depicted in the video or whose family is depicted in the video is a witness or prospective witness in the case. But I don't recall, and I'm, as we discuss this matter now, I'm struggling to find an example of that. An instance where footage of a mass killing of unknown victims was pursued to identify. I mean, first you try to do so as much as possible, but if for the forensic reasons Joanna mentioned, if nothing else. But I can't say I recall an instance where for considerations of the impact on family members who might be exposed to this without warning, an investigation was pursued in order to justify the public dissemination or public viewing of that piece of evidence in court. And I think, and I'd want to check that with colleagues, and Joanna's here and she may have a particular set of examples in mind. I think that kind of practice even extended to people who were known or who, at least in terms of location and maybe even neighborhoods, and were depicted in such publicly displayed evidence. So to the extent we think that's a human concern that needs to be addressed, my recollection is that it's a gap, and there's a difference between the protections offered to witnesses and within the context of the rules of evidence and procedure, and the protective measures that apply to more generalized evidence that depicts a large number of unnamed victims.
Well, funny enough, Alan, I was thinking of the Scorpions video, when this was a video that was found. Well, you'll know more than I do because you dealt with Karadzic and that part of it, but was handed over to ICTY and showed the killings of a number of the men at Srebrenica by the Scorpion paramilitary group. And I suddenly, and it was the most horrifying thing I've ever seen. And I was wondering whether the families of those people whose faces you could see quite clearly sometimes will have reacted when they saw that suddenly being played, even if they'd been told in advance. And I don't imagine they would have been, because nobody would have at that stage been able to identify them properly. So I mean, that's what I was thinking of when I was talking about that.
And there's another aspect, I suppose, of this, which is I've been reading a lot of stuff recently from the Syrian context about the content creators. So these are people who often, put their lives at risk to go and capture evidence of maybe chemical weapons attacks or shellings or what have you. And, there has been some really interesting research done interviewing these people who said that they felt almost used in a way, that the evidence that they'd gone to great lengths to capture was just kind of taken and used without their knowledge in accountability processes or used by fact-finding activities. So yeah, I don't know, is there anything in the protocol, Lindsay, about sort of getting the consent of the creator, or yeah?
Well, I mean, I think it's addressed most through the ethical principles, which doesn't give you any sort of hard answers or direction. Just because, I mean, how the law works is if you're photographed or videotaped when you're in public, you actually don't really have rights to your image of that. If consent, maybe if it's being sold, but if it's being used for newspapers or in a court case, you don't really have a legal claim. So then it comes to the ethical issues of what seems right on your part. And I think you have to take many different factors into consideration, and to the extent possible, get consent where you can, but it's not always possible. In terms of, victims, if you can display the material in a way that protects their dignity, maybe you're blurring out faces and things like that. I think those are some tools to do it in a way that protects dignity. But again, it's a tricky issue, and I don't know that the protocol gives any clear-cut advice. And it's also, I mean, the protocol is directed at the people who are finding the open source information. So it's not really directed at advice for content creators and what you should or should not upload. Yeah, and I think more and more though now, content creators do know if they upload things publicly that, the laws allow them to be used in different ways. They've given their consent at the time of upload to a public platform. So I think it's in the ethical realm for investigators.
Great. Can I ask a question? What are your thoughts about how this kind of evidence impacts on fair trial rights, and particularly maybe equality of arms? How can a defence counsel work against this machinery where you have specialised open source investigators or people who are specialised in doing things like geolocation, satellite imagery? Or is the only solution to better equip defence teams with the resources to hire their own counter expert? Any thoughts on that?
Well, I mean, I think very obviously, and at a minimum, it implicates the transitory nature of what's available on open source. Mm-hmm. So the issue of equality of arms is a little bit difficult to apply in a context where one party in an adversarial system is investigating events, and there is no quote unquote defense at that stage in the sense we're talking about, and the material won't be there. And that, I think, implicates some other aspects of the protocol in terms of what needs to be preserved and what not, and what was looked for and what was not, and bias involved in that or not involved with that. That's one more reflection, I think, of the manner in which this new mechanism for delivering old kinds of evidence gives rise to a number of new issues that Lindsay and her teams have been identifying and grappling with, but that need to be looked at and practices developed to address on an ongoing basis. And that's what's happening. I mean, people are dealing with it always, but it's that question identifies one of the many issues arising from both the breadth of this material, its volume, and its transitory nature.
I think the defence in a domestic trial, certainly at the moment here in the UK, would probably be able to muster a very strong argument about why it shouldn't be admitted unless they had the opportunity themselves to have it examined by an expert of their choosing. The difficulty, of course, is that there isn't the money available because, and there aren't that many experts either, I don't think, at the moment. But I think in an international trial, criminal trial, it would probably just go in on the same principle, you know, that we've been talking about. You admit it, and then you just see what weight you're going to attach, judging by the other evidence that surrounds it.
And yeah, and just in response to that, I mean, all these issues have to be put in context too. Again, it depends upon the centrality of that piece of evidence in the case. So if it's another piece of evidence bolstered and corroborated by all kinds of other pieces of evidence, that issue is obviously less significant. If it's the one single piece upon which the court is asked to rely, then the question of how much it has or can be tested suddenly becomes more prominent.
Yeah, I agree. Yeah.
And of course, oh, sorry, Lindsay.
Oh, I agree with what's been said. The only thing I would add to it, in addition to the fact that, you know, this is something we're grappling with, have to think about the fair trial rights and implications. This material is that it's a type of material and evidence that the defense wants to use too and has used. Often actually the people who get stronger skills at digital open source investigations are not law enforcement because they don't have the subpoena power able to get warrants, so they have to rely on those methods. So actually they have the stronger skills, whereas law enforcement, if they have those other tools, they don't strengthen the digital open source investigation tools. And you've actually seen this, I think, at the Special Tribunal of Lebanon. The defense was the first to proffer open source evidence, WikiLeaks material, and that kind of thing. So I think having a standard that safeguards it and looks at these things is important, but I also think it's going to be a benefit to the defense as much as it is to the prosecution.
Great. And of course, in the ICC, the prosecutor has this duty to investigate exonerating material equally. Great. Okay, I can't see any more questions coming in the Q&A. Have the panelists anything you'd like to raise or ask each other or discuss that we haven't touched on so far?
Well, I want to go back to something Alan said at the beginning, because I thought that was quite interesting, which he said was that the expansion of the ability for members of the public to make their views known. Now, a lot of people might think this was not an advance, but in fact a regression, because what you're getting is a great deal of deeply unpleasant, vitriolic, as the word that seems to be used here is trolling or whatever. And I don't think that's an advance at all, or that something that we should applaud. I mean, the persecution, if you like, of J.K. Rowling over her views on transgender, I think typify this. So, Alan, I'm appalled by the fact that members of the public can make their views known, and to such a wide extent.
I didn't actually register a personal view on it, nor did I try to characterize it as a positive or a negative from a social or cultural point of view. Simply that the platform was expanded. So previously it had simply been newspapers and television coverage and books and that's what you would think of as open source, and trying to get into people's heads was a whole different matter, which involved a much more painstaking investigation. And now many people are volunteering to tell the entire world what they're thinking and doing. So that's the sense in which I meant it.
Right. No, I mean, I know that, but I mean, I think it is actually, I think it's one of the more interesting aspects of the huge expansion of digital communication as to what, if any, action countries should be taking about this. And at the moment, because the companies that run YouTube, Google, whatever it is, are vast international ones. It's very difficult to restrict this. And as against the argument, but at least that way also evidence of atrocities, I mean, are coming to light, which might otherwise not.
This kind of brings to mind something that Lindsay mentioned actually in passing, which is that the internet is, right, I can't remember the exact term you used, but that it's often used as a place for misogynistic attacks on women. And I'm thinking specifically about recent news stories on deep fakes and how this deep fake technology can be used to make these hyper realistic videos purportedly, you know, showing explicit content with well-known women's faces superimposed onto it. And I suppose the question I'm thinking about is, as this deepfake technology, I think at the moment, it's fair to say it's still a little rough around the edges. You could do things like slow down a video and see that the way the mouth is moving doesn't match with how the speech is progressing or whatever. But as that becomes more advanced, will that act as a bar to any sort of video evidence, for example, open source video evidence being admitted? Because the opposing side can quite easily say, well, it could be a deep fake, it could be false. What do we think the emphasis is? Lindsay?
Well, I think, and Claire Wardle from First Draft News has said this very articulately, and I'm not going to get it right, but the concern of deepfakes is not so much the deepfakes themselves fooling people, but that it creates this excuse where then people can discount videos because they're using the fact that it might be a deepfake. I think you're right that the technology is not quite there yet. And actually on the protocol, if you look at the protocol, our cover image is a deepfake satellite image, which maybe now if you know that, you can tell really just to start talking about this, getting into this conversation. I think it's going to be an issue, but still some of the other forms of disinformation, of just decontextualized photos. You see, you know, images from a conflict 3 years ago being recirculated and recharacterized, or how things are, videos that are staged or videos that have been just edited as a shallow fake, are still the sort of greater concerns in verification at the moment. Yeah.
Any thoughts on that, Alan? Just Korner?
Well, I would just say that the mere fact of the points made by you, Yvonne, and by Lindsay bring us back to Joanna's admissibility concerns. You know, no judge who heard this stuff would be unable to forget it, and to the extent those kinds of concerns were not communicated to the parties so that they could be addressed one way or another, they're presumably going to play a role in the assessment of admissibility and weight outside the presence of the parties after the evidence has been dealt with by them. So now, and it makes it incumbent upon the parties to be as current with all of the issues surrounding the integrity of digital open source materials, so they can proactively and preemptively address it in court. But you know, there's so much information out there, you don't know what the court may have heard, and you may not be current with all the problems. And then finally, it implicates the same thing we were talking about before, which is if you don't know what the judge's concerns are, then the likelihood of overkilling the problem is increased with multiple witnesses to address every theoretical possibility, even if it in fact doesn't concern the court at all.
Joanna, do you want to come in on this fake news narrative? Is this something you've seen in maybe in cases here in England and Wales where someone has tried to introduce a YouTube video, for example, and then someone else has said, well, it's fake, or we can't trust it?
Actually, I mean, we particularly in gang cases, you get the prosecution arguing very often these days that YouTube evidence is admissible, and the defense strongly objecting because it's usually a rap video and the lyrics are absolutely terrible. By and large, most judges are admitting them on the understanding that the jury will be directed to take great care in how they use this evidence. There are not that many cases, certainly, admittedly, I should say straight away, I deal with fraud cases by and large, so I don't anymore do many gang violence or murder cases. But by and large, I'm not aware that there's a huge amount of that kind of video evidence being sought to be put before a jury, other than I say in gang-related cases. But I'm not the best person to ask about that.
Yeah, and I think that raises a point actually, which is something we've touched on, but maybe not quite fully addressed in this webinar, which is about when we talk about open source evidence, we're talking about potentially huge spectrum of types of evidence, everything from newspaper reports, NGO reports, to an individual image or video that has been independently verified or geolocated, and some expert had said, look, we can tell it was taken at this time and this date. So yeah, it's something we've been thinking about a lot in the project, is a sort of a taxonomy of open source information, rather than just kind of making broad conclusions about different types, or about open source as a category. I wonder, is there any need to develop like specific rules on this, or is it better to just let the case law develop and take it on a case-by-case basis? Sometimes you might have an NGO report that's very reliable, or yeah, or sometimes you might have an image that is on its face prima facie reliable, but actually in this particular context there are concerns about it. Any thoughts on that? Developing specific rules on open source evidence.
Only to say that I don't think those two things are incompatible. That is, the development of protocols and best practices, and the eventual establishment of a jurisprudence that governs their treatment in court. It'll presumably be informed by that. It will bolster the efforts at admissibility by those who have been made aware of and have attempted to follow those practices insofar as possible. It'll identify where reliability issues begin and may become attenuated. So certainly doesn't seem like an either or thing to me. They look like they're not only compatible but complementary.
Lindsay.
Well, I would say one thing is, this is another reason why having very well-reasoned judicial opinions that actually do talk about the admissibility or get into the way to itemize pieces of evidence is important, instead of maybe this holistic view that doesn't actually address the reasoning, because you do have all of these fact-specific issues, and the law is going to need to develop through precedent, you know, and maybe binding precedent, so it's actually building along and you don't get inconsistent jurisprudence across one case.
Oh, but that assumes that precedent works.
Right. That's true. Yeah.
Which it doesn't in most certainly most civil law jurisdictions. It's not binding, and that's, it's always seemed, I think, to all common lawyers, the one difficulty we have in understanding why you would have a system whereby precedent wasn't binding, because there's no certainty. But as they keep on saying about European law, it is a living instrument. it is flexible. It takes account of changing circumstances. But I absolutely agree with you. I think it's really important that where there are appeals, and particularly if this happens in ICC, there's a reasoned judgment on a specific aspect so that everybody can see how the court reached its decision, the reasoning, and then apply it to future cases. And even though there is no system of precedent, I think most judges realize that there's got to be a good reason to depart from a ruling that shows exactly how it's been arrived at. So I do think that's right. And there's no one size fits all in this, as you say.
Super interesting, and I think it ties into something you and I, Judge Korner, have discussed in the past, which is this holistic versus atomistic approaches, and to what extent you have granularity on this particular type of evidence was treated or given this type of weight, and how that then impacts on, someone mentioned the Special Tribunal for Lebanon judgment earlier, where you have 2,000 pages of a judgment, so yeah, it's about sort of striking that balance, isn't it? I'm conscious the time is against us, but this has been such a fascinating and thought-provoking discussion. So all that remains is for me to thank our panelists. And any further points that you want to raise, or should we leave it at that? So thank you all very much. Judge Korner, as I said at the beginning, we continue to keep our fingers crossed for you, and we hope to have some good news before too long. And Alan and Lindsay, thank you so much also for joining us. It's been really wonderful to have your expertise, and thank you all of our attendees as well. So thank you all very much. Goodbye.